Welcome to California Indian Legal Services Dependency 101 webcast. It is intended only to be a basic overview of the California State Court dependency process. It is in no way intended to constitute legal advice or apply to specific facts. Each case is different, and for further information, updated research and/or legal counsel may be appropriate. So what is juvenile dependency? Juvenile dependency, or dependency, is the area of law involving children who are or may be at risk of abuse or neglect. There's a difference between juvenile dependency cases and other cases in state court proceedings. In these actions, the best interest of the child is paramount, as is confidentiality provisions, and the juvenile dependency court has exclusive jurisdiction over all issues relating to the child's custody. And where the child is an Indian child, the Indian Child Welfare Act applies to those proceedings. So let's look at the difference. Although the juvenile court action is called a custody proceeding, the juvenile court judge is focused on the protection and care of the child. So unlike family court, the focus is not in resolving disputes between the parents. That includes child support disputes and/or divorce matters. In California, jurisdiction over a child welfare matter can go to the tribal court where the child is an Indian child, or state court. State court consists of the superior or trial court level. The trial or superior court's decision would be reviewed by its corresponding appellate court, whose decision would be reviewed by the California Supreme Court, and depending on the facts and legal issue, may be reviewed by the U.S. Supreme Court. So let's talk about governing laws. Remember, each case is fact-specific and different rules may apply. But generally, in California, juvenile cases are governed by Welfare and Institutions Code sections. For juvenile dependency actions, that starts at sections 200 to 395. For juvenile delinquency actions, that starts at sections 600. There may also be provisions of the Family Code, Probate Code, Evidence Code, and others that may apply to the facts of your case. For interpretation of those code provisions, you will also want to look at the California Rules of Court and case law interpretations of those provisions. There may also be corresponding federal provisions that applies. For an Indian child, the Indian Child Welfare Act would apply. You may also look at the Code of Federal Regulations and the Bureau of Indian Affairs guidelines for state courts and agencies in Indian child custody proceedings. Again, those have been updated and there are new provisions effective as of December 2016. So let's look now to the juvenile dependency process itself. In comparison to other state court actions, where a trial resolves all issues regarding those parties, the juvenile dependency court process is broken into a series of hearings where the juvenile court judge answers specific questions regarding those parties. Ultimately, those questions funnel down to the permanence and safety of the child. In California, the hearings are broken into the initial or detention hearing, jurisdiction hearing, disposition hearing. There are several different types of review hearings: selection and implementation hearing, permanency review hearing, and a post-permanency review hearing. At the end of each hearing, after the court has heard all issues and received all evidence, the court will issue findings and orders This is an example of the findings and orders after a 6-month pre-permanency review hearing. As you can see, the judge just answers the questions corresponding to each issue. The Judicial Council forms are useful reference tools and can be accessed at the court's website at www.courts.ca.gov/forms. They will provide you with the issues for your hearing. So what is a finding and order, and what are the differences between the two? A finding is when the judge decides the existence or non-existence of some fact. Findings are conclusions made by the judge about facts or the law that support an order. Some findings are required to make an order, and if missing or incomplete, the order may be deficient. So let's look at an example. For an Indian child, that child cannot be removed unless there is clear and convincing evidence that continued custody of the child by the parent or the Indian custodian is likely to result in serious emotional or physical damage to the child, and the court can find that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family, and that these efforts have proved unsuccessful. After a hearing and at the conclusion of evidence, the court will make an order of whether or not the child should be removed under that standard. In order to make an order of removal, the court has to find, based on the evidence presented, that, for example, active efforts were made. So let's now turn to the specific stages of dependency. A juvenile dependency action would start with a referral and investigation. A child welfare referral may be made to a tribal or county agency that the child is at risk of abuse or neglect. When a law enforcement is involved and the officer has reasonable cause for believing that the minor is at risk of abuse or neglect, and that the minor has an immediate need for medical care, or the minor is in immediate danger of physical or sexual abuse, or the physical environment or the fact that the child is left unattended poses an immediate threat to the child's health or safety, the officer may be able to take the child into temporary custody without a warrant. But the officer must first attempt to contact the child's parent or guardian to see if the person is able to assume custody of the child. If the parent or guardian cannot be contacted, the peace officer shall notify a social worker in the county to assume custody of the child. The officer then must either release the minor or deliver the minor to the social worker. The social worker must then immediately investigate. The law presumes that the social worker will release the child to the parents or guardian unless certain circumstances exist as outlined in Welfare and Institutions Code section 309A. Before the child is taken into custody, a social worker must consider whether the child can remain safely in his or her residence. The social worker will consider a number of factors depending on the facts of that family. This could include, for example, are there any services that can be given to either parent or to the child to eliminate the need to remove the minor from the custody of his or her parent, guardian, or caretaker? Are there any programs or services that the parents can be referred to that would eliminate the need to take temporary custody of the minor? Have the parents already been referred to such assistance? Can the offending person leave the child's home? If so, are there any other orders that may need to be made to ensure the child's safety, for example, a restraining order? Is the parent willing to accept services and participate in corrective actions? Ultimately, if an alternative to detention of the child is available, the social worker must consider the less restrictive alternative. In lieu of filing a petition, the social worker could decide to undertake a program of informal supervision of the child without the court taking jurisdiction. The social worker could instead file a juvenile court petition without detaining the child in a family maintenance action. Ultimately, whether to file the petition is in the discretion of the social worker. Let's look now to see what happens if the social worker does decide to file a juvenile dependency petition to initiate the dependency court jurisdiction. Recall that the juvenile dependency court's jurisdiction is over the area of law involving children who are or may be at risk of abuse or neglect. In California, these reasons are listed under Welfare and Institutions Code Section 300, subsections A through J. California defines what constitutes abuse or neglect in Welfare and Institutions Code Section 300, subsections A through J. Here's a list of each one of those sections. For each child that the social worker is asking the juvenile dependency court take jurisdiction over, the social worker will file a juvenile dependency petition whether or not the child has been detained from the parent or guardian. As you can see, the first page consists of information regarding the case and the parties. The second page and those following include the attachment for each Welfare and Institutions Code subsection A through J that the social worker alleges the child is defined by. As you can see, each attachment has the legal standard, and immediately under that, the social worker will type out the facts that support the allegation that the child is described under that subsection. Once the juvenile dependency petition has been filed, the court must set the initial hearing. If the child has been detained from the parent or guardian, the initial hearing must be set for no later than the next court day. If the child has not been detained, then the initial hearing must be set for no later than 15 court days. The purpose of the initial detention hearing is for the court to advise the parties of the contents of the juvenile dependency petition, their rights, and the nature of and possible consequences of the juvenile court proceedings. Even though the juvenile dependency petition has already been filed with the court, it is not at this hearing that the petitioner or the agency must prove that the allegations are true. Instead, the standard at this hearing is whether or not there is a prima facie showing. A prima facie showing is there enough alleged in the petition on its face to support being in the juvenile court proceedings. If there is enough evidence to show that the child might be abused or neglected as defined under the Welfare and Institutions Code section 300 subsections A through J, then the court will set the matter for a jurisdiction hearing, whereby the court will determine whether or not the allegations are true, thereby warranting the court's taking jurisdiction of the child. An example to illustrate what is a prima facie showing. Recall, for a child to be under the jurisdiction of the Juvenile Dependency Court, because the child is alleged to have been described under Welfare and Institutions Code 300A, the physical abuse must have been inflicted by the parent or the guardian. So, a petition allegation under that section would be insufficient, even under a prima facie showing, if the facts alleged state only that the child was seen with a bruise that occurred while being babysat by mother's ex-boyfriend. On its face, the facts alleged do not support that the parent or guardian inflicted the physical abuse as defined under Welfare and Institutions Code 300 subsection A. Upon making the findings and orders from the initial or detention hearing, the court will set the next hearing for jurisdiction. If the child has not been detained from the parent or guardian, the next hearing must be set for no later than 15 days from the order of detention. If the child has not been detained, then the jurisdiction hearing must be set no later than 30 days from the initial findings and orders. At the jurisdiction hearing, the court must determine whether sufficient evidence exists that the child is described by one or more of the provisions of the Welfare and Institutions Code section 300, subsections A through J, that defines abuse or neglect. There are three things to think about for the jurisdiction hearing. 1. Jurisdiction is permitted regardless of whether the child was in the physical custody of both parents or was in the sole legal or physical custody of only one parent at the time that the events or conditions occurred that brought the child within the jurisdiction of the court. Jurisdiction is taken over the child who has been proven to be abused or neglected under California law. Second, allegations can only be sustained or found as true as to presumed legal parents, not alleged. 3. In the event that facts alleged in the petition need to be modified or amended to fit the offer of proof through the hearing, there is a process to doing so. The petition would not be dismissed on those technical grounds. If, after hearing all the issues and receiving the evidence at the hearing, the court finds that the allegations of the petition are not true, it shall order that the petition be dismissed and the child be returned to the physical custody of the parent or guardian immediately. If instead the court determines by a preponderance of the evidence that the allegations of the petition are true, the court will take jurisdiction and set the matter for a disposition hearing. If the court orders that it takes jurisdiction, the juvenile court now has exclusive jurisdiction over that child. This means that as long as the child is a dependent of the court and until jurisdiction is ordered terminated, the juvenile court has exclusive jurisdiction to make custody orders regarding the child. This includes custody and placement of the child, visitation orders, that's with the parent, siblings, and even grandparents. The court will also make orders regarding the child's medical, mental health, and educational needs. What this also means is that while the juvenile dependency case is pending, neither parent can go into, for example, the family court to ask for any order affecting the child's custody. This also includes visitation and/or restraining orders. Upon making jurisdiction findings and orders, the juvenile court will then proceed to a disposition hearing. In some counties and in some cases, the juvenile court may have set the disposition hearing to occur on the same date as the jurisdiction hearing. If not, then the juvenile court will set the hearing for a later date. If the child is out of the home, the disposition hearing must occur no later than 10 court days from the jurisdiction orders. If the child has not been detained from the home, the disposition hearing must not occur any later than 30 days from the jurisdiction orders. In some cases, there may be continuances. No continuance can be granted that would cause the disposition hearing to be completed any later than 60 days from the date that the child was initially detained. The limited exception is where the court finds that exceptional circumstances exist for a further continuance beyond this date. But even then, the disposition hearing cannot be completed any later than 6 months from the initial detention. Now that the juvenile court has determined at the jurisdiction hearing that the child is or may be at risk of abuse or neglect, the purpose of the disposition hearing is for that court to make such orders to ensure the safety, protection, and well-being of that child. In doing so, the court will consider a full array of social and health services to help that child and family and to prevent re-abuse of the child. The focus must also be on the preservation of the family to the extent possible. After hearing all issues and receiving all evidence, the juvenile court will determine whether or not to declare the child a dependent of the court and permit the child to still remain at the parent or guardian's home with an order of family maintenance services to be provided to the family, or to remove the child and place with the non-custodial parent, or to declare the child a dependent of the court and remove from the parent or guardians. Alternatively, the court also has the option to terminate jurisdiction and not declare the child a dependent of the court, or to order that the child not be declared a dependent of the court and to instead place the child under a program of supervision. Or the parents can even voluntarily relinquish the child to the State Department of Social Services, to a county adoption agency, or to a licensed private adoption agency. Whether the child is or is not removed from the parent or guardian's home, if the judge declares the child a dependent of the court, there are 3 other issues that must be addressed. 1, a case plan will be developed and ordered that consist of services that the parents and/or the child must participate in to address or alleviate the need for the court's jurisdiction. Second, the court will make orders regarding where the child should be placed while those services are being implemented. Third, where the child is outside of one or both parents' home, the court will make visitation orders. So let's look at the case plan. The parent or parents must be offered services designed to help the parents overcome the problems that led to the court's taking of jurisdiction. There must also be an individual case plan for each child receiving foster care payments. The goals of the case plan are to ensure that the child receives the protection and safe and proper care and case management, provide services to improve conditions in the parent's home, facilitate the child's safe return to a safe home or the child's permanent placement, and to address the child's needs while in foster care. Regarding the child's case plan, it is important to remember to include terms that ensure that the dependent child receives age-appropriate extracurricular enrichment and social activities. The case plan must also describe the services to be provided concurrently to the child to achieve legal permanence if reunification efforts fail. The case plan must be updated as the service needs of the child and family dictate. At minimum, the case plan must be updated with each status review hearing, but no less than every 6 months. Let's take, for example, the situation where a parent is ordered to go into substance abuse residential care, and the residential care is a 45-day program. The case plan would need to be updated before the 6-month status review hearing upon the parent's graduation and completion of that service. The court must also make orders regarding visitation for the child. Visitation shall be as frequent as possible, consistent with the well-being of the child. The court will not make any visitation order that jeopardizes the safety of the child. The court will make a visitation order between the parent or guardian and the child. Visitation must also be ordered between the child and any siblings, unless the court finds by clear and convincing evidence that sibling interaction is contrary to the safety or well-being of either child. And where the child was removed, the court must also consider whether the family ties and best interest of the child will be served by granting visitation rights to the child's grandparents. A review hearing must occur at least every 6 months, regardless of whether the child is or is not in the parent or guardian's home. At each review hearing, the presumption exists that the child will be returned to the parent or parents or the guardians unless it is proved by a preponderance of evidence that the child would be at substantial risk of abuse or neglect if returned to the parent or guardians. The social service agency must be shown to have made the required efforts to assist the family in alleviating the risk of harm and whether there are any other services that might be appropriate. The court's option is to return the child. If the child is returned, the court may order the termination of dependency jurisdiction, where the child can be protected without the need for further court supervision. You see this occurring in those cases where the child had been previously placed with a non-custodial parent and the court determines that supervision is no longer necessary. The court may also order continued dependency services and set a review hearing within 6 months as a family maintenance action. Where the court does not order the child returned to the parent or guardian's home, there is a presumption that the parent or guardians will receive an order for additional reunification services. The exception would be where the child or his sibling was under 3 years of age when taken into custody, where the parent's whereabouts remain unknown, or where the child was placed with a non-custodial parent. If reunification services are continued, the court must make specific findings. If the court continues reunification services, the services are subject to the time limits under Welfare and Institutions Code, Section 361.5a. The court must set a date for the hearing no later than 12 months from the date the child, quote, entered foster care as defined in the Welfare and Institutions Code. If the court instead terminates reunification services to both parents, the court must schedule a Welfare and Institutions Code Section 36626, which is also known as the Selection and Implementation Hearing, to occur within 120 days. If reunification services is terminated only to one parent, then a 36626 hearing is not yet set, and a review hearing will be set for the parent receiving continuing services. The same 3 issues in disposition hearing are still required at the review hearing. The court must again make an order for a case plan, placement, and visitation of the child to address the needs of the child and the parents or guardians. The court can, however, modify the terms and conditions of those services ordered at the disposition or prior review hearing as is appropriate, or order additional services reasonably believed to facilitate the return of the child to the parent or legal guardian. The services offered are to serve the dual purpose of assisting the parents or guardians to reunify and also to concurrently prepare the child for permanence should reunification not occur. Remember, the statutory deadline for reunification services is 12 months from the date that the child was removed from the parent's care. This means that if the child is not returned to the parent or guardian, or further reunification services are not ordered, then the court must terminate reunification services and schedule a selection and implementation hearing pursuant to the Welfare and Institutions Code 36626 within 120 days. To continue reunification services beyond this statutory deadline, the court must find either that there is a substantial probability that the child will be returned to the physical custody of his or her parent or legal guardian and safely maintained in the home within an extended period of time. In order to find substantial probability, the court must find all of the following. 1. that the parent or legal guardian has consistently and regularly contacted and visited the child. 2, that the parent or legal guardian has made significant progress in resolving problems that led to the child's removal from the home. 3, the parent or legal guardian has demonstrated the capacity and ability both to complete the objectives of his or her treatment plan and to provide for the child's safety, protection, physical and emotional well-being and special needs of the child. Or, to continue reunifications beyond the statutory deadline, the court must find that reasonable services have not been provided to the parent or legal guardian to reunify. Under no circumstances can reunification services be ordered for any more than 18 months from the date the child was originally taken from the physical custody of his or her parent or legal guardian. Status review hearings must still occur even when the child is in the home. These are called family maintenance review hearings. These too must occur in no more than every 6 months. The purpose of this hearing is for the juvenile court judge to determine whether or not the juvenile court's continuing jurisdiction or supervision is still necessary. The court must terminate its dependency jurisdiction unless the court finds that the petitioner or agency has established by a preponderance of the evidence that existing conditions would justify initial assumption of jurisdiction under Welfare and Institutions Code 300, sections A through J, or that such conditions are likely to exist if supervision is withdrawn. At this hearing, the juvenile court can order continued jurisdiction and set the matter for further review hearing. Alternatively, the court can terminate its jurisdiction, and when it does so, it has 2 options. 1, the court can refer the matter to the family court to issue orders determining the custody of or visitation with the child for the other parent. Or, the juvenile court may issue orders itself determining the custody of or visitation with the child and the other parent. The court can also issue protective orders pursuant to Welfare and Institutions Code, section 213.5. When the juvenile dependency court orders that its jurisdiction be terminated and decides to issue its own custody orders, when making the orders, the juvenile court is not bound by the same presumptions in family court regarding joint custody. Instead, the court must look to the best interest of the child. So although visitation can be granted to the non-custodial parent, the juvenile dependency court has the authority to issue conditions in the orders, including, for example, a requirement that the parent continue services such as substance abuse or counseling. Any custody orders made by the juvenile court is final and can only be modified or terminated on a showing of 1, a significant change of circumstances, and 2, a showing that the change is in the best interest of the child. Once the juvenile court has made an order terminating or denying reunification services to both parents, the court will set a selection and implementation hearing within 120 days. Remember, at this point, there had already been an earlier court finding that reunification with the parents or guardians was not to occur, and the court terminated reunification services. This means that the purpose of this hearing is to focus only on the selection and implementation of the child's permanent plan. The information the court will consider will relate only to its goal of providing a stable, permanent home for the child. What this means is that the parent's or guardian's rights and interest in the child is not at issue. This means that although the parents or guardians may wish to address their interest and care in the child, the court will not accept or hear that information, as it is not relevant to the findings and orders that the court must make for this hearing. Should any party wish to address the issue of the parents' or guardian's interest in the child and or the progress they have made towards reunification, such information must properly be brought as an issue for the court to consider by way of what is referred to commonly as a 388 petition to change court order. So in making an order, selecting and implementing the child's permanent plan, the permanency options that the court will consider is adoption with termination of parental rights, tribal customary adoption, guardianship, or long-term foster care. Please note that long-term foster care or a planned permanent living arrangement is no longer an acceptable long-term plan for any children or foster youth under the amended California statutes. Upon making the findings and orders at the selection and implementation hearing, the court will set post-permanency review hearings to occur at least every 6 months thereafter. Even after the child's permanent plan has been selected and ordered, a status review hearing must still occur at least every 6 months. The purpose of the hearing is for the Juvenile Dependency Court to monitor and determine whether or not the agency or social service department has made reasonable efforts to make and finalize the permanent placement for the child. We thank you for your time, and for more information, please visit www.calindian.org under our self-help section under Child Welfare. Thank you.